In a bold and divergent move, Supreme Court Justice Clarence Thomas stood apart from his fellow justices in regards to a contentious case challenging the authority of the Occupational Safety and Health Administration. On a fateful Tuesday, the court made the decision to reject an appeal presented by Allstates Refractory Contractors after a lower court had previously dismissed the Ohio company's lawsuit against OSHA. The crux of the lawsuit revolved around the argument that a federal law enacted in 1970, which bestowed OSHA with extensive powers to establish workplace safety standards, violated Article 1 of the U.S. Constitution. This article explicitly grants the authority to create laws solely to Congress and no other branch of the federal government. 7 justices, in a unified front, chose not to entertain the appeal. However, Justice Thomas, accompanied by his conservative counterpart Justice Neil Gorsuch, expressed their willingness to hear the case. While Justice Gorsuch remained silent on his rationale, Justice Thomas took the opportunity to voice his dissenting opinion in a written statement. In his dissent, Justice Thomas emphasized the undeniable significance of the question at hand, whether the expansive authority of the Occupational Health and Safety Administration aligns harmoniously with the fundamental structure of our beloved Constitution. A captivating revelation has emerged, revealing that a minimum of 5 justices within the esteemed court have displayed a keen inclination to reevaluate the court's prevailing stance on Congress's bestowal of legislative authority. This revelation was unveiled through an eloquent piece of writing, which described the petition as an exceptional conduit to accomplish precisely that purpose. In this remarkable composition, Justice Thomas boldly asserted that the Occupational Safety and Health Act, nestled within the vast expanse of the United States Code, may very well be the most extensive conferral of power to an administrative agency. He further contended that if the sweeping grant of authority does not transgress the boundaries of bestowing legislative power upon an agency, then it becomes an arduous task to fathom what could. In a strikingly similar vein, Justice Thomas posited that it would be equally objectionable if Congress were to grant the Internal Revenue Service the power to levy any tax upon an individual that it deems appropriate. This audacious stance taken by Justice Thomas is by no means an isolated incident, as he has consistently demonstrated a propensity to diverge from his esteemed colleagues on numerous occasions. Last month, he stood alone in defiance during a groundbreaking case concerning the rights of gun owners. The other justices, by a margin of 8-1, upheld a federal law designed to safeguard victims of domestic violence. This week, he fearlessly called out his fellow justices, accusing them of making unnecessary remarks, after the court unanimously decided not to settle constitutional questions surrounding social media laws in Texas and Florida. In a concurring opinion, Thomas expressed his agreement with sending the cases back to lower courts, but vehemently disagreed with the court's decision to offer its own interpretation of certain aspects of those statutes. His dissenting voice on Tuesday emerged as a powerful counterpoint to the conservative majority's recent blow to federal regulatory power, as they overturned a pivotal 1984 ruling in Chevron v. Natural Resources Defense Council. This landmark decision had previously instructed judges to defer to government agencies when it came to interpreting ambiguous laws. The U.S. Supreme Court's ruling on presidential immunity, which established new standards for evidence in criminal indictments against former President Donald Trump, was criticized by legal analyst Glenn Kirshner as being conjured out of thin air. In a stunning verdict, the justices have delivered a resounding 6-3 ruling, bestowing upon Trump an impenetrable shield of immunity for all his actions carried out within the boundaries of his presidential duties, as defined by the Constitution. This momentous decision has now thrust the former president's federal election interference case back into the hands of a lower court, tasked with deciphering which of the activities listed in the indictment against Trump can be deemed as official acts. However, this ruling has not been met with unanimous applause, as legal experts and adversaries of the ex-president have unleashed a torrent of criticism. Justice Sonia Sotomayor, the author of the dissenting opinion on behalf of the 3 liberal justices, expressed her dissent with a heavy heart, fearing for the very essence of our democracy, and sounding the alarm on the far-reaching implications of